Welcome to LexTalks Legal Topics. Simplified, a podcast designed to make law approachable. Today we're diving deep into basic issues in the implementation of international humanitarian law, IHL, and enforcement at the national level, a topic that's particularly relevant for anyone interested in Indian legal studies.
It's fascinating how these international rules actually play out within a country's own legal system.
Absolutely. We've got a great mix of legal handbooks, guidelines, scholarly articles, and even real-world examples to guide our deep dive today. So let's get started. First things first, what exactly is international humanitarian law, and why should we care?
Well, IHL is a set of rules that aim to limit the suffering caused by war. It's not about deciding whether a war is legal or not, but about setting boundaries on how wars are fought, and importantly, protecting people who are not involved in the fighting.
So things like protecting civilians, prisoners of war, and wounded soldiers, even in the middle of a battle.
Exactly. And this is where it gets interesting for us. IHL doesn't exist in isolation. It intersects with a country's own laws, its constitution, criminal laws, and military codes.
So it's not just about international treaties, it's about how those treaties are integrated into a country's legal system.
Precisely. Imagine an Indian soldier commits a crime while on a peacekeeping mission abroad. Whose laws apply? India's, the host country's. This question of jurisdiction highlights the complex relationship between IHL and national law.
That's a great example. It shows how intertwined these different layers of law can be, especially in today's world, where countries are increasingly engaged in international operations.
And this brings us to a crucial point, state responsibility. Countries have a fundamental obligation to ensure that their soldiers, even when operating outside their territory, uphold IHL.
So whether it's a peacekeeping mission or even running a prison abroad, the state is accountable for what its soldiers do.
Absolutely. It's not just about punishment after a violation occurs. Investigating all allegations, even if they don't lead to prosecution, shows a real commitment to upholding IHL. Think about it. Respect for the law means there are consequences for breaking it.
It sends a strong message both domestically and internationally that a country takes IHL seriously.
Exactly. But things get more complex when we consider the changing nature of warfare. One of the biggest shifts in recent decades has been the rise of non-state actors.
Groups like armed militias, rebel groups, and terrorist organizations.
Yes. These non-state actors play a significant role in conflicts around the world, raising questions about how traditional IHL, designed primarily for state-to-state conflict, applies to them.
So how do you even determine if a non-state group is bound by IHL? Is it any group that picks up arms?
It's not that simple. There needs to be a certain level of organization and structure for a non-state group to be considered subject to IHL. They need to have a command structure, control territory, and be capable of sustained military operations. Not just any gang.
So what are the challenges when it comes to holding non-state actors accountable for violating IHL?
That's where things get even trickier. Unlike states, these groups often lack sophisticated legal systems, making accountability difficult. Plus, their motivations can differ drastically from those of states. They might see violating IHL as necessary to achieve their goals.
So for them, breaking the rules might be a strategic decision, not a lapse in judgment.
Unfortunately, yes. And this poses a challenge to the traditional IHL framework, which was built on the idea of reciprocity between states. If one state broke the rules, the other could respond in kind. But that dynamic doesn't work as effectively with non-state actors.
It sounds like the international community is still figuring out how to effectively address these challenges.
It's definitely an evolving area of law, but even as we navigate the complexities of non-state actors, it's important to remember that IHL violations are ultimately committed by individuals, even if the state ultimately bears responsibility.
So we're talking about individual accountability, holding specific soldiers or commanders responsible for their actions, not just blaming the state as a whole.
Exactly. And there are three main avenues for this military discipline and law national courts, using the country's own criminal laws and international tribunals specifically for war crimes.
And it seems like the evolution of international tribunals from those after World War II to the Permanent International Criminal Court reflects a growing emphasis on individual accountability.
It's a fascinating development. It highlights how the mechanisms for enforcing IHL are constantly adapting in response to new challenges.
So how do countries actually implement all of this? What steps do they take to make IHL a reality within their own legal systems?
That brings us to domestic implementation. There are two main approaches: monist systems, where treaties become law directly upon ratification, and dualist systems, where separate legislation is needed to incorporate treaty rules into national law.
I'm guessing India falls into the dualist category.
You're right. India, like many countries, requires a separate act of parliament to give effect to international treaties. However, implementing IHL goes beyond just adoption. Many treaties demand practical measures, like specific laws to protect IHL emblems or setting up national information bureaus to track missing persons during conflict.
It sounds like a complex process.
It definitely is, and it requires a deep understanding of both international obligations and the nuances of a country's legal system. Speaking of responsibility, let's talk about command responsibility. Individuals can be held accountable not just for their own actions, but also for the actions of those under their command, right?
So planning or instigating a war crime is as bad as carrying it out yourself.
Exactly. And commanders carry a particularly heavy burden. They can be held liable for crimes committed by their subordinates if it's proven they either ordered the crimes or failed to prevent them.
It seems like a crucial aspect of IHL enforcement is recognizing that responsibility extends up the chain of command.
Absolutely. A commander's failure to prevent or punish IHL violations by their troops is a serious breach of their responsibility.
It sounds like an immense responsibility, especially considering the chaotic nature of armed conflict.
It is, but this principle is essential for ensuring accountability and deterring future violations.
Even when punishing IHL violations, everyone deserves a fair trial, right?
Yep.
That's a fundamental principle of justice.
You're absolutely right. Even in the context of war crimes, IHL upholds the right to a fair trial.
What are some specific rights protected by IHL for individuals accused of war crimes? What guarantees are there to ensure they're not treated unjustly?
Several key protections are in place. IHL guarantees the right to sufficient time and resources to prepare a defense, the right to examine witnesses and present one's own evidence, and the presumption of innocence until proven guilty.
These sound like fundamental principles of due process, making sure the accused has a real chance to defend themselves.
Exactly. IHL also ensures the accused's right to be present at the trial, guaranteeing their active participation in the proceedings.
It's reassuring to know that even in war, these basic principles of justice are maintained.
It's a testament to the enduring importance of human rights, even in the most challenging circumstances. This intertwining of IHL and human rights law is definitely worth exploring further.
Absolutely. Now let's move on to another interesting aspect of IHL implementation legal reviews.
This is where things get particularly fascinating, especially in our technologically advanced world. States have a duty to review the legality of new weapons before they're adopted.
So it's not just a wartime concern. It's about continually ensuring any new weapon system complies with international law.
You got it. This review process needs to ensure weapons comply with both treaty-based IHL and customary international law, which evolves over time through state practice.
I imagine that's a tall order, especially with technology advancing so rapidly.
It's incredibly complex. A new weapon might be legal in some situations, but illegal in others. The review must be thorough, considering all potential uses and consequences.
So it's not just about banning certain weapons, but also about restricting the use of legal weapons to prevent misuse.
That's a critical point. IHL recognizes that even legal weapons can be used in ways that violate international law. It's about ensuring that technological advancements don't lead to even greater human suffering.
That makes a lot of sense. Now, shifting gears a bit, our research also delved into the concept of humane treatment. What does that actually mean in the context of war? It seems almost like a contradiction.
It is a fundamental principle of IHL, and it applies to everyone who falls into enemy hands, regardless of their status or actions. Common Article 3 of the Geneva Conventions, a cornerstone of IHL, lays this out clearly.
Common Article 3 sounds important. What exactly does it say?
It states that people not taking an active part in hostilities, including prisoners of war, and those who are wounded, sick, or detained, must be treated humanely at all times.
So no torture, cruel treatment, or degrading punishments, even for enemy combatants.
Precisely. It sets a minimum standard of humane treatment that must be upheld in all circumstances, and this applies even in non-international armed conflicts, like civil wars.
So even when a country is fighting its own citizens, there are still rules that must be followed.
Absolutely. Common Article 3 applies in all armed conflicts, regardless of the parties involved. It's a universal principle of humanitarian protection.
That's reassuring to know. But what if a state argues that certain actions, even if they seem harsh, are necessary for security reasons?
IHL acknowledges that states have a right to take measures for security and control, especially when dealing with prisoners or those captured during conflict.
So they can detain people, restrict their movements, maybe impose curfews.
Yes, but those measures must be balanced against the fundamental right to humane treatment. Any restrictions on individual liberty must be necessary and proportionate to the security threat.
So there needs to be a clear justification, and the measures can't be overly harsh or go beyond what's necessary for security.
Exactly. That's where IHL safeguards come in. It outlines specific rights and protections for those deprived of their liberty, ensuring their basic needs are met and they are treated with dignity.
This humane treatment principle seems to be a recurring theme in IHL. It emphasizes that even in war, there are limits.
That's right. And it reflects the idea that certain fundamental rights are inherent to every human being, regardless of whether they're on the winning or losing side of a conflict. Our research also highlighted the close relationship between IHL and human rights law. There seems to be a lot of overlap.
Yes, it does seem like there's a strong connection between the two. Can you elaborate on that?
While IHL specifically addresses situations of armed conflict, human rights law has a broader scope protecting individuals from abuses of power by state authorities in all circumstances.
So human rights law applies in peacetime and wartime.
That's right. However, there are key distinctions. For instance, their geographical scope can differ.
You mean where they apply? Could you give an example?
Sure. During an international armed conflict, IHL applies not only in the territories of the warring states, but also wherever their armed forces are engaged, even in international waters. Human rights law traditionally applies within a state's territory or where it exercises effective control over individuals.
So if Indian troops are deployed on a peacekeeping mission in another country, IHL would apply to their actions even though they're outside of Indian territory.
Precisely. That's why understanding the interplay between IHL and human rights law is so crucial. They both contribute to protecting individuals, but they operate in slightly different ways and have different scopes of application.
It does sound like a complex area of law.
It can be. But despite their differences, both IHL and human rights law share a common goal to uphold human dignity and protect fundamental rights even in the most challenging situations. Now, shifting to enforcement, our research highlighted the evolution of international mechanisms for holding individuals accountable for war crimes.
It's interesting to see how the world has grappled with that over time. Can you walk us through some of the key developments?
It has been a remarkable journey. For a long time, the primary responsibility for enforcing IHL rested with states themselves through their own military discipline systems and national courts.
So it was largely up to each country to police its own soldiers and punish any violations.
That's right. But the atrocities of World War II led to a shift in thinking. The horrors of that conflict highlighted the limitations of relying solely on national enforcement.
It makes sense. If a state itself is committing war crimes, you can't expect it to hold its own people accountable.
Exactly. The post-war period saw the establishment of international military tribunals to prosecute individuals for war crimes. The Nuremberg and Tokyo trials were landmarks in international criminal justice.
And those trials paved the way for the International Criminal Court, right? A permanent court specifically designed to prosecute individuals for war crimes, genocide, and crimes against humanity.
Precisely. The ICC represents a major step forward in the international community's pursuit of accountability for the most serious violations of IHL.
But the ICC's jurisdiction is limited, isn't it? It can only step in when national courts are unable or unwilling to prosecute.
That's the principle of complementarity. The primary responsibility for investigating and prosecuting war crimes still lies with individual states. The ICC acts as a court of last resort.
So even with the ICC, national implementation of IHL remains absolutely essential.
More important than ever, states need robust domestic laws and effective enforcement mechanisms to ensure that IHL is upheld and violators are held accountable.
It's about creating a system where justice is served both nationally and internationally. What about the role of national IHL committees? What are they and what do they do?
They are bodies set up within a country to advise and assist the government on IHL implementation. They play a crucial role in coordinating different government departments, promoting IHL awareness, and ensuring that national laws and practices align with international obligations.
So they're like internal watchdogs, making sure the state lives up to its IHL commitments.
That's a great way to put it. They're not enforcement bodies themselves, but they play a vital role in strengthening a country's IHL framework.
Our research also highlighted non-judicial mechanisms for enforcing IHL.
Yeah.
It seems these can be just as important as formal legal proceedings.
Absolutely. Non-judicial mechanisms encompass a range of tools and approaches that can promote compliance with IHL. They might involve fact-finding missions, public reporting on IHL violations, or even diplomatic pressure on states failing to uphold their obligations.
So it's about using a variety of methods to encourage states to do the right thing, even if it doesn't always involve going to court.
Precisely. And these non-judicial mechanisms can be particularly effective when formal legal processes are difficult or politically sensitive. Speaking of specific violations, attacks on healthcare are especially concerning. IHL provides strong protections for medical personnel facilities and transports during armed conflict.
So things like hospitals, ambulances, and medical staff are off limits even in battle.
Absolutely. Attacking these protected entities is a grave violation of IHL and can have devastating consequences.
Why are these attacks happening? Is it just soldiers ignoring the rules in the heat of the moment?
While that can occur, the reality is often far more complex. Unfortunately, healthcare facilities and personnel are increasingly being deliberately targeted in modern conflicts.
Deliberately targeted. What would be the motive behind that?
There are some disturbing trends. Armed groups might view healthcare facilities as strategic assets or see medical personnel as supporting the enemy.
So they might attack a hospital to deny medical care to their opponents, or target doctors treating wounded enemy combatants.
Exactly. In other cases, hospitals might be attacked because they're perceived as sheltering enemy fighters or being used for military purposes.
But even with legitimate security concerns, IHL requires taking all feasible precautions to avoid harming civilians in medical facilities.
That's right. And there are clear rules for when a protected entity like a hospital is misused for military purposes.
What kind of rules are we talking about?
Before taking action against a protected object, the attacking party must issue a warning giving a reasonable time limit for the misuse to stop.
So no bombing a hospital without warning and a chance for them to respond.
Exactly. Even if the warning is ignored, any attack must still be proportionate and avoid excessive civilian casualties.
It seems like IHL takes significant steps to protect healthcare, even in the most difficult circumstances.
It does. But the reality is that these protections are often disregarded and the consequences are devastating.
What kind of consequences?
When healthcare is under attack, it's not just doctors and nurses who suffer. Entire communities are deprived of essential medical services. People might die from treatable conditions because they can't reach a hospital or fear being caught in the crossfire.
It creates a chilling effect that undermines the entire healthcare system.
Exactly. And the long-term consequences can be profound. Damaged healthcare infrastructure takes years to rebuild, and the psychological trauma of these attacks can linger long after the fighting has ended.
It reminds us of the human cost of IHL violations and how these attacks extend far beyond the immediate victims. Another heartbreaking aspect of war is the issue of missing persons. It must be agonizing for the families.
It truly is. The uncertainty and lack of closure for families of the missing can be unbearable, and IHL recognizes the importance of addressing this issue.
So what does IHL say about missing persons? What obligations do states have?
IHL requires states to take all feasible measures to account for people who go missing during armed conflict.
So searching for the missing, gathering information about their whereabouts, and notifying families.
Yes, states also have an obligation to prevent people from going missing in the first place. Properly documenting detainees, ensuring their access to communication, and facilitating the work of organizations like the Red Cross in tracing missing persons are crucial.
It's a multifaceted approach: prevention, information gathering, and support for families.
Precisely. And the ICRC's Central Tracing Agency plays a vital role in these efforts.
What does the Central Tracing Agency do?
It acts as a neutral intermediary collecting and sharing information about missing persons from all sides of a conflict. They work tirelessly to reconnect families, provide information about loved ones, and facilitate the return of remains.
It sounds like incredibly important work, especially given the emotional toll these situations take on families.
It is. The right to know the fate of missing relatives is a fundamental humanitarian principle, and IHL provides a framework for upholding that right even amidst armed conflict. Now let's shift our focus to another complex and sensitive area: cultural property. What do we mean by cultural property in the context of war?
That's an interesting one. It doesn't immediately come to mind when thinking about the laws of war. What falls under that category?
We're talking about monuments, historical sites, religious buildings, museums, archives, even archaeological sites. Essentially anything that holds cultural, historical, or religious significance for a community or society.
So IHL recognizes that these places and objects deserve special protection during armed conflict. Why is that so important?
Cultural property represents the identity, history, and heritage of a people. Destroying or damaging it can be devastating to a community's sense of self and its ability to recover from conflict.
It's like tearing at the fabric of a society, erasing its past and undermining its future.
Exactly. That's why IHL prohibits attacks on cultural property unless it's being used for military purposes.
So a historic fort used as a military base could be a legitimate target.
Potentially, yes. But even then, the attacking force must take all feasible precautions to minimize damage to the cultural aspects of the site.
What about looting or theft of cultural artifacts? Is that covered by IHL?
Absolutely. IHL prohibits plundering cultural property. Stealing or vandalizing artifacts is a serious violation.
IHL seems to go to great lengths to protect cultural heritage, even amidst war. How effective are these protections in reality?
Sadly, cultural property is often targeted during conflict. We've seen countless examples of historical sites deliberately destroyed, religious buildings desecrated, and museums looted.
It's a tragic loss, not just for the communities directly affected, but for all humanity.
It is. And these acts often go unpunished. Bringing those responsible for cultural destruction to justice can be challenging, especially in the chaotic aftermath of conflict.
Accountability is crucial. To deter future attacks on cultural property, we need to send a clear message that these crimes will not be tolerated.
Absolutely. And that requires a concerted effort from the international community to investigate these crimes, prosecute the perpetrators, and support the restoration and preservation of cultural heritage. Now let's turn our attention to children who are particularly vulnerable during armed conflict.
It's heartbreaking to think about the impact of war on children. What does IHL say about protecting them in conflict zones?
Protecting children is a core principle of IHL with specific rules to safeguard their well-being in conflict zones.
What are some of the key protections IHL offers children?
First, children are considered civilians and entitled to the same general protections as other non-combatants.
So they can't be deliberately targeted, and attacks must distinguish between civilians and military objectives.
Exactly. But IHL goes further, recognizing that children have special needs and vulnerabilities that require additional safeguards.
Can you give us some examples of these additional protections?
Of course, IHL requires that special attention be given to the care and upbringing of children orphaned or separated from their families due to conflict. It also prohibits recruiting children under 15 into armed forces or groups.
So no child soldiers under 15.
That's right. And even for those over 15, IHL sets clear guidelines to ensure recruitment is voluntary and that children are not forced or coerced into taking up arms.
It sounds like the international community is serious about tackling the issue of child soldiers.
Yes, the optional protocol to the Convention on the Rights of the Child, specifically addressing children in armed conflict, has been widely ratified. It raises the minimum age for recruitment and participation in hostilities to 18.
So the trend is towards greater protection for children, recognizing that they should be shielded from the horrors of war.
Absolutely. This reflects a growing awareness of the long-term psychological and social damage armed conflict inflicts on children. Our research also touched upon education in conflict zones. It seems schools and educational facilities are often targeted during war.
It's distressing to think about schools becoming battlegrounds. Why are they targeted? Are they seen as legitimate military objectors?
In most cases, no schools are often attacked because they symbolize state authority or are used as shelters for displaced people.
But IHL is clear, schools should be protected, not targeted.
Exactly. IHL prohibits attacks on schools unless they're being used for military purposes. And even then, the attacking force must take all feasible precautions to avoid harming students and teachers.
What about situations where schools are used as bases by armed groups? Doesn't that make them legitimate targets?
It's complex. IHL acknowledges that misusing schools for military purposes can undermine their protected status, but there are guidelines for addressing these situations.
What kind of guidelines?
The attacking force must issue a warning giving the armed group a reasonable time limit to stop using the school for military purposes.
So they can't attack without trying to resolve the situation peacefully.
Precisely. Even if the warning is ignored, any attack must be proportionate and minimize civilian harm.
IHL seems to strive for a balance between military necessity and protecting education.
It does, but unfortunately these protections are often violated. Attacks on schools deprive children of their right to education, disrupt their lives, and create a climate of fear with lasting consequences.
It highlights the importance of upholding IHL principles, especially those protecting the most vulnerable. On that note, our research mentioned the concept of transitional justice. Can you explain what it is and how it relates to IHL?
Transitional justice refers to the processes societies use to address past human rights abuses and IHL violations after conflict or repression.
So it's about dealing with the legacy of violence and moving forward in a way that promotes healing and reconciliation.
Exactly. Transitional justice encompasses various approaches: criminal prosecutions, truth commissions, reparations programs, institutional reforms, and even memorialization efforts.
It's a multifaceted approach, recognizing that there's no single solution to the complex challenges of post-conflict recovery.
That's right. And the specific mix of transitional justice mechanisms will vary depending on the context. There's no one-size-fits-all approach.
How does IHL fit into all of this?
IHL provides a legal framework for holding perpetrators accountable, a key aspect of transitional justice.
So if a state has ratified the Geneva Conventions or other IHL treaties, it's legally obligated to investigate and prosecute individuals who have committed war crimes.
Precisely, and this obligation doesn't vanish just because the conflict has ended.
So transitional justice can ensure IHL remains relevant even after the fighting stops.
Absolutely. By addressing past IHL violations, transitional justice processes can help prevent future abuses, strengthen the rule of law, and promote lasting peace.
It sounds like a crucial step in breaking the cycle of violence and building a more just society.
It is, and it recognizes that achieving sustainable peace requires more than just ending the fighting. It requires addressing the root causes of conflict, promoting accountability, and fostering respect for human rights and the rule of law.
Technology seems to play a significant role in both implementing and violating IHL. It appears to be a double-edged sword.
It is. Technology can be a powerful tool for promoting compliance with IHL. For example, satellite imagery and open source intelligence can monitor conflict zones, document violations, and gather evidence for potential prosecutions.
So technology can help to make IHL enforcement more transparent and effective.
Exactly. And new technologies are constantly being developed to improve humanitarian assistance, protect civilians, and even prevent IHL violations.
But you mentioned technology being a double-edged sword. How can it be used to violate IHL?
Well, the same technologies used for good can also be used for harm. Cyber attacks can disrupt critical infrastructure, spread misinformation, and even facilitate war crimes.
So we need to be mindful of the potential for misuse.
Absolutely. We need clear legal frameworks and ethical guidelines to ensure that new technologies are used in a way that upholds IHL principles and minimizes civilian harm.
It sounds like a constant game of catch-up with technology evolving faster than the law can keep up.
It can feel that way. That's why ongoing dialogue and collaboration between legal experts, technologists, and policymakers are crucial. We need to anticipate the challenges and opportunities new technologies present and ensure they promote peace, protect civilians, and uphold humanitarian principles. Now let's consider civil society's role in promoting IHL. How can NGOs and other civil society groups contribute to IHL implementation?
It seems like they would have a unique perspective and ability to reach people on the ground.
Exactly. Civil society plays a vital role. NGOs can monitor and document IHL violations, advocate for policy changes, provide humanitarian assistance, and educate communities about their rights and responsibilities under IHL.
So they act as watchdogs, advocates, and educators all in one.
That's a great way to put it. They often have a deep understanding of the local context and can bridge the gap between international law and local communities.
Their work seems especially important where governments might be reluctant to enforce IHL or where access to conflict zones is restricted.
Absolutely. NGOs can often access places that governments or international organizations can't, and they can provide a voice for those marginalized or silenced during conflict.
Their efforts seem essential to ensuring that IHL is not just a set of abstract principles, but a reality on the ground.
They are, and their efforts are often crucial for holding states accountable for their IHL obligations and promoting a culture of respect for human rights and the rule of law. Now, considering the challenges of enforcing IHL in the 21st century, we've already touched on some, like the rise of non-state actors and rapid technological change. Are there other pressing challenges?
It seems like the world is becoming increasingly complex, and it's hard to imagine that wouldn't impact the enforcement of international law.
You're absolutely right. One of the biggest challenges is the increasing complexity of armed conflicts themselves. Many modern conflicts are no longer clear-cut wars between states. They involve a multitude of actors with shifting alliances and motivations.
So it can be difficult to even determine who's fighting whom, let alone who's responsible for IHL violations.
Exactly. And this complexity makes it harder to apply traditional IHL principles, which were designed for state-to-state conflicts.
It seems like IHL is constantly evolving to keep pace with the changing nature of warfare.
It is. Another major challenge is the issue of impunity. All too often, those who commit IHL violations escape justice.
Why is that? Is it simply a lack of political will to prosecute war crimes?
Political will is certainly a factor, but there are also practical challenges. Gathering evidence in conflict zones can be incredibly difficult and dangerous. Witness intimidation is a common problem, and many victims are reluctant to come forward for fear of reprisals.
So even with the desire to prosecute, the practical realities can make it very difficult to bring perpetrators to justice.
That's right. And this culture of impunity sends a dangerous message that IHL violations are acceptable and that those who commit them can act with impunity.
It seems like we need to find ways to strengthen IHL enforcement mechanisms and make sure that those who violate its principles are held accountable for their actions.
It is a daunting task, but a crucial one for upholding international law and ensuring justice. We need to find ways to strengthen IHL enforcement mechanisms and make sure that those who violate its principles are held accountable for their actions.
That makes sense. Going back to something we touched upon earlier, what about the rapid advancement of technology? How does IHL adapt to things like autonomous weapons systems?
That's a huge challenge and a hot topic right now. We're talking about weapons that can select and engage targets without human intervention.
Those killer robots we often hear about in the news, they sound like something out of science fiction.
It seems that way, but it's becoming our reality. The development of these systems raises a lot of ethical and legal questions. Can a machine be programmed to comply with IHL? Who is responsible if an autonomous weapon commits a war crime?
It's a bit unsettling to think about the implications. Who would be held accountable? The programmer, the commander who deployed it to the government?
Exactly. It's uncharted territory, and the international community is still grappling with how to regulate these new technologies and ensure they don't undermine IHL.
It seems like we're at a crossroads. Technology is advancing at an incredible pace, and we need to make sure that the humanitarian principles of IHL aren't left behind.
I agree. This is why open dialogue and debate on these issues are so important. We need legal experts, ethicists, scientists, and policymakers to work together to find solutions.
It's about ensuring human control and ethical considerations are at the forefront, even as technology progresses. But it's not just about these complex new technologies, right?
Yeah.
Basic understanding of IHL principles seems crucial at all levels.
Absolutely. Everyone involved in armed conflicts, from soldiers and commanders to policymakers and even the general public, needs to understand the rules.
Because if people don't understand the rules, how can we expect them to follow them?
Exactly. We need to foster a culture of respect for IHL where it's seen as the foundation for conduct during war.
It can't just be abstract principles written down somewhere. It needs to be integrated into how we think and act.
I couldn't agree more. And this education needs to start early. Teaching young people about IHL and peaceful conflict resolution is essential for building a more humane and just future.
It's about planting the seed for a world where war is not seen as inevitable, but as a failure of our collective humanity.
Beautifully put. At its heart, IHL is about protecting human dignity and those caught in the crossfire. It reminds us that even in the darkest of times, compassion matters, and there are lines we must not cross.
This deep dive into IHL has been incredibly insightful. We've covered so much ground, from the fundamental principles of IHL to the complexities of its implementation and enforcement.
It's a complex and ever-evolving field, but a vitally important one. As we've discussed, we all have a part to play in ensuring that its principles are upheld and that it continues to adapt to meet the challenges of our changing world.
Thank you for joining us today for this deep dive. You've been listening to LexTalks Legal Topics Simplified. Be sure to subscribe for more insights into the fascinating world of law. Until next time.